It's 8:36 on Wednesday, March the 25th. The House Criminal Justice Subcommittee is now in session. Everyone sign in and let's take the roll. Madam Clerk, please take the roll.
Mr. Chairman, you have 6 members present. You have a quorum.
Thank you, ma'am. Members, any personal orders before we begin today? Chair Lady Littleton.
Thank you, Mr. Chairman. I have a shout out today from Stewart County. They're so kind to come at least once a year to come and hang out with us, and her name is Glory Malone. So let's make her welcome, please. Stand up.
Representative Scarborough.
Thank you, Mr. Chairman. We have some guests here, Tennessee Association of Chiefs of Police. Just raise your hand and wave at us. Thank you.
Representative Atchley. All right.
I call for questions.
No, members, I have Addison Collins from Stewart County High School, and she was sitting over here, but now she has moved over here. So thank you for being with us today. Anyone else? Seeing none. Our Sergeant of Arms, Mr. Tyler Muniz, has swapped places with us, so we'll go to him for our weekly words of wisdom.
Good morning, everyone. Today's words of wisdom come to you from the Italian stallion, Rocky Balboa. Remember, the mind is your best muscle. Big arms can move rocks, but big words can move mountains. Y'all have a great day.
Hey, thank you. All right, for those that are in the audience in this packed house and those that are watching worldwide via the web, there are a lot of bills that have been taken off notice. There are several that were disposed of in the Senate, so we will be going down the calendar, but maybe skipping around a little bit. So members that are watching in their offices, be paying attention. We're going to try to go down the calendar, but as we get to a member that has a bill early in the calendar and one later in the calendar, we're going to try to accommodate them at that time as well. So without further ado, item 18, House Bill 1812 by Representative Russell is off notice. Item 47, House Bill 1053 by Representative McKenzie is off notice. Item 48, House Bill 2439 by McKenzie is off notice. Item 43, House Bill 2266 by Representative Leatherwood off notice. Item 25, House Bill 2414 by Representative Stevens is off notice. Item 44, House Bill 2401 by Representative Sparks off notice. Item 57, House Bill 465 by Representative Hilton Haynes off notice. Item 61, House Bill 1662 by Representative Sherrill off notice. Item 65, House Bill 2285 by Representative Mitchell off notice. Item 67, House Bill 956, Representative Brooks off notice. Item 68, House Bill 949 by Representative Brooks off notice. Brings us to item number 1, House Bill 1755 by Representative Rutter. You have a motion and second. You recognize there are no amendments. Please proceed.
Okay. Good morning. Which number did you say is first?
1755.
Okay, I got you. Well, I've often said that the very best bills come from your constituents. And this is one that did come from a constituent of mine. It was about this time last year. I got an email from a police officer in Marion County that is in my district and from the town of Kimball. And he's Captain Chris Webb. And this is what Captain Webb wrote me. He said, one of my police officers stopped a DUI suspect inside an active school zone. The lights were on and kids were being picked up. And the DUI suspect had a blood alcohol content of 2.87. Legal is below 0.08. He was unable to locate any law pertaining to an enhanced charge or an enhanced sentence for this offense. And therefore, House Bill 1755 which simply states, which adds a mandatory minimum sentence of 30 days incarceration for a person convicted of driving under the influence if the person was within a marked school zone and warning flashers were in operation. That's my legislation.
Thank you for that explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting now to send House Bill 1755 to full judiciary. Has everyone voted? Anyone wish to change their vote? We're waiting on Chairman Farmer to get logged in. There you go. Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1755 moves on to full judiciary.
Thank you.
Let's go to item number 24, members. Item number 24 is going to be House Bill 1757 by the Representative Rutter. You have a motion and a
Okay, you
second.
moved me up. Okay, 1757.
Yes, ma'am.
I thought I was next. Okay.
You have an
17
amendment.
I do have an amendment.
16064.
That's it. That's it.
You
That's it.
recognized on the amendment. Does the amendment make the bill?
I think it was an addition to the bill.
Okay, well, let's talk about the amendment.
The
then we'll-
amendment just specifies that this information from this legislation will be included in all department-approved handgun safety courses. That's what the amendment does.
Thank you. Any questions on the amendment? Seeing none, objection to the question. Seeing none, we're voting to adopt Amendment Code 16064 on the House Bill 1757. Those in favor will say aye. Those opposed, the ayes prevail. You adopt. We are on your bill as amended.
Okay, this is another one that comes from not from one of my constituents, but from something tragic that happened in my community on July 4th of this year. And I will just read you a little background about this tragic circumstances. While celebrating 4th of July with his wife and family, Mr. John Cobb was struck and killed by a stray celebratory bullet during fireworks celebrations. John was an active member of his community, serving as a worship leader in his church for 20 years. John's wife, Mrs. Michelle Cobb, administered CPR, not knowing that her husband had been struck in the head by a stray bullet. John was transported by Vanderbilt by helicopter, eventually declared brain dead. His lungs, kidneys, and liver were donated to help save lives of 3 people. Winchester Police Department and TBI are still investigating this incident. John and his wife own guns. She's not seeking a broad gun control. The family just simply wants people to be informed of the dangers, and they want a law to prevent this from happening to others. Therefore, House Bill 1757 would make it a Class A misdemeanor if a person recklessly discharges a firearm into the ground, air, body of water, or an object in proximity of to the person. If the firearm is discharged at a place of public gathering or a public event where there are at least 25 people in attendance at the time of the discharge. And this, as I stated before, this information would also be included in all department-approved handgun safety courses. I would appreciate your positive consideration for this piece of legislation, and I stand here for questions.
Thank you for that explanation. I have Representative Powell on the list.
Thank you. Fully support the bill. Question, in that case, was anybody ever found to have discharged it?
No one, not yet.
Okay, sorry. Thank you.
Thank you, Chairman Russell.
Thank you, Mr. Chairman. And the way I understand this would make it a Class A misdemeanor.
Yes, sir.
Would that conflict with reckless endangerment that says it's a Class E felony to discharge a reckless endangerment committed with a deadly weapon?
I spoke with the district attorney about this, and they said that it did not
Thank you.
conflict. They
Okay.
were in support
Okay.
or neutral, whatever.
Anyone else? Leader Lambert.
Just Representative, I want to thank you for fighting hard for, your community. I know you called me right after this happened, and it was very disturbing and heartbreaking for this family. And to Chairman's point a while ago, I mean, it's another option when I think endangerment has not actually been proven, but something very unwise and something somebody should never do. Any of us that grew up hunting and fishing and around firearms our whole life are taught, never point a firearm at anything that you don't intend to kill, and be very careful where any bullet goes. Always watch and be very cognizant of the fact that that's a dangerous, deadly weapon that you're utilizing. And to fire a gunshot up into the air in a celebratory fashion is a horrible decision, and just is not something anybody should ever do. And a misdemeanor at the very least, when that's done in proximity to other folks, whether it's endangering them or not, just seems reasonable. So,
Thank you.
But I know you're bringing it to fight for your community, and I want to say I applaud you and appreciate you doing so, and I hope they do as well.
Thank you.
Anyone else for the sponsor? Seeing none, any objections to the question? Seeing none, we're voting to send House Bill 1757 as amended to full judiciary. Has everyone voted? Waiting on, yeah, sorry. Everyone's voted. Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 9 ayes and 0 noes.
The ayes prevail. House Bill 1757 as amended moves on to full judiciary.
Thank you, Mr. Chairman and committee.
Thank you. Chairman Farmer.
Thank you, Mr. Chairman. Members, I have a shadow today. I have Ethan Smith from Stewart County High School. Ethan, would you stand up there and let's make him feel welcome today? Appreciate you being here. Thank you.
Members, let's jump to item 22. Just because of a scheduling conflict here, we're going to go to item 22, House Bill 354. You are recognized. There's Amendment Code 14302.
Correct. That's the
You are
amendment.
recognized on the amendment. Does the amendment make the bill?
It does.
All right. Any objection to adopting Amendment Code 14302 on the House Bill 354? Seeing none, all those in favor of doing such, say aye. Those opposed, the ayes prevail. You adopt or own your bill as amended.
All right, thank you. And I've found a free phone up here too. That goes with this bill. House Bill 354 gives TBI the discretion to determine the best investigative approach of a suspected elder financial exploitation. Instead of requiring coordination with the DA as they're now required to do, this bill allows TBI to investigate whenever appropriate. TBI may coordinate with the district attorney general, other law enforcement agencies, and it also allows coordination with prosecutors and other agencies when needed. In summary, House Bill 354 clarifies how TBI handles reports of suspected elder financial exploitation. And with that, Mr. Chairman, I renew my motion.
Thank you for that explanation. Fantastic bill. Anyone have a question? Representative Powell.
Just a question, and I appreciate you tackling the issue of elder financial exploitation. It's a very serious issue. In the bill amendment, it says they shall coordinate with the district attorney general and the appropriate. If judicial district, does this enable them to always coordinate, or if the DA, can he go about investigating this, or he or she investigate this on his own? And then, or her own, and then come back, and do they have to coordinate, or does this just give the option to?
Thank you. And yeah, it allows them to coordinate with the DA. Right now, they're required to. When we did the TBI hotline that we established it last year, it required them to coordinate with the DA, but this one will allow them to do it, or it'll allow them, if it's an urgent need, that they can go ahead and investigate it immediately without the DA's approval.
Thank you.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 354 as amended to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 9 ayes and 0 noes.
The ayes prevail. House Bill 354 is amended, moves on to full judiciary.
Thank you, Mr. Chairman. Committee.
Item number 2, House Bill 1444 by Representative Gillespie. You recognize there are no amendments.
Thank you, Mr. Chairman and committee. House Bill 1444 strengthens Tennessee's response to the most extreme and intentional acts of violence against animals by elevating aggravated animal cruelty from a Class E to a Class D felony, and also by allowing courts to just classify juveniles who commit aggravated animal cruelty as serious youthful offenders. These are not just neglect cases. We're talking about very intentional, deliberate, violent acts. And with that, I welcome any questions.
Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1444 to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 noes, and 1 present not voting.
The ayes prevail. House Bill 1444 moves on to full judiciary. Item number 3, House Bill 1484 by Representative Gillespie. You're recognized. There's Amendment Code 14525. You wish to proceed?
Yes, and that amendment makes the bill.
All right, you're recognized on the amendment. The amendment makes the bill. Any objection to adopting Amendment Code 14525 on the House Bill 1484? Seeing none, all those in favor say aye. Those opposed, ayes prevail. You adopt. Your own bill is amended.
Thank you, Mr. Chairman and committee. This bill involves the Memphis Safe Task Force. As you all know, President Trump and Governor Lee on September 15th of 2025 announced it, and it was officially launched on September 29th of that year. To roughly this date, there have been over 7,400 arrests, 1,219 illegal firearms seized, and over 150 missing children safely located. Given the success of the Memphis Safe Task Force, this legislation is designed to ensure we lock in these historic gains. This bill will require that certain charges resulting from Memphis Safe Task Force members be disclosed within 3 business days to the Attorney General, both speakers, the DA conference, and the U.S. Attorney in the district. If the DA reaches a plea agreement, lowers a charge, dismisses a case, or otherwise declines to prosecute. There are roughly 14 offenses that this would apply to. This legislation does not, I repeat, does not restrict the discretion. It only requires disclosure. And this bill will also sunset on June 30th, 2028, unless otherwise reauthorized. The DA's conference helped me drafting this legislation, and they are neutral. The U.S. Marshal's Office has also coordinated with me, and they are positive on this. I ask for a favorable vote, and I welcome any questions. Thank you.
Thank you for your explanation, Representative Salinas.
Thank you, Chairman. I don't see ICE listed on here. Is the Memphis Task Force collaborating with ICE?
That has nothing to do with this bill, because I can read the offenses that this would apply to if you'd like me to.
My question is the task force collaborating with ICE? Yes or no?
I'm not on the task force, so I mean I assume they are, but this has nothing to do with ICE.
Okay, thank you.
Any other questions for our sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 1484 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 2 noes.
The ayes prevail. House Bill 1484 is amended, moves on to full judiciary. Item number 4, House Bill 1802 by Representative Capley. You are recognized. There's Amendment Code 13376. Do you wish to proceed with that amendment?
Yes, sir.
All right, you're recognized on the amendment. Does the amendment make the bill?
Yes, sir, Mr. Chairman.
All right, let's, Any objection to adopting Amendment Code 13376 on the House Bill 1802? Seeing none, we're voting to adopt such. All those in favor say aye. Those opposed, ayes prevail. You adopt or own your bill as amended.
Thank you, Mr. Chairman and committee. As many of you will remember, last year we did the Private Property Protection Act in conjunction with several different law enforcement agencies in the state. We are bringing that back. It's a little bit more limited in this regard, but basically says that if deadly force is your last and only option to protect your private property, you can use it. And that's what the bill does, as amended.
Any questions for the sponsor, Representative Powell?
And we talked about this last time, but how does one go about, I mean, if no one is there to witness it, then you could always just use the explanation of it was the only justifiable, at that point, reason. So how does one go about, proving or disproving that that was the case?
Oh, thank you. Well, you have to do that now anyway. So, I mean, if you're alone, I mean, in court, the DA, you would have to prove your innocence. You'd have to prove the fact that you were defending yourself. Right now, this doesn't change anything like that.
Yeah, I guess my concern here is it seems to lower the bar and give this much more probability of being used as a reason or excuse for murdering another person if they came onto your property to trespass or do some of these things that you include. So, yeah, I don't know. Still have objections to the bill, but happy to hear your response.
Thank you, Mr. Chairman. Specifically in commission of arson, burglary, robbery, aggravated robbery, aggravated cruelty to animals. Yeah, and you have to reasonably believe that you can't protect your property otherwise. So it's we're not shooting the pizza man.
Chairman Farmer.
The Domino's driver. That's what I said. Yeah.
Thank you, Mr. Chair. And Representative Kaplan, I wanted to ask you this, and just to make it clear, I see this bill being very similar to the self-defense statute. And it's my understanding that it's your intent just to let folks know that's available if somebody coming in trying to commit arson or something like that, maybe come after you with a knife or a gun or something, that this is available, and just making it clear that basically the self-defense statute is available to protect your property if that person's threatening your life or the life of others. Is that my understanding? Am I correct?
Yes, sir, Mr. Chairman. Thank you. Okay. Thank you for those comments.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1802 as amended to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 2 noes.
The ayes prevail. House Bill 1802 as amended moves on to full judiciary.
Thank you.
Have you got another one?
Mr. Chairman.
What number are you there,
House
sir?
Bill 2428. I'm 70 something, sir.
46. You're a little off there, sir.
Oh. Well,
All right. Item number 46, House Bill 2428 by Representative Capley. You are recognized. There are no amendments.
no, sir, Mr. Chairman.
All right, please proceed.
Thank you, sir. Members, as many of you will remember, we did the Back the Blue Act, which increased the offense of assault against a police officer from a misdemeanor to a felony. This adds first responders to that. All first responders.
Leader Lambert.
Thank you, Mr. Chairman. Since that's where you thought you were, I was going to make a motion to roll this to item number 70 something. But the chairman told me not to make that motion, so I'm not going to.
Thank you, Leader.
Anyone else? Representative Ashley. He calls for the question. Any objection? Seeing none, we're voting to send House Bill 2428 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes, 0 noes, and 1 present not voting.
And the ayes prevail. House Bill 2428 moves on to full judiciary.
Thank you, Mr. Chair. Thank you.
Let's jump back one right here to item number 45, House Bill 2563 by Representative Gillespie. You are recognized. There's Amendment Code 14857. You're recognized on the amendment. Does the amendment make the bill?
It does.
All
Thank
right.
you.
Let's adopt Amendment Code 14857 on the House Bill 2563. Those in favor say aye. Those opposed, the ayes prevail. You adopt. We're on your bill as amended.
Thank you, Mr. Chairman and committee. This bill as amended would create 20 assistant public defender positions, 20 legal secretary positions, and 12 investigator positions, and 12 and 7 social workers positions. Sorry about that. And with that, I can go into more detail if you need me to.
Very good. Any questions for the sponsor? What other details were you going to go into on this?
Oh,
Never mind.
okay.
No questions for the sponsor. Any objection to the question? Seeing none, we're voting to send House Bill 2563 as amended to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 9 ayes and 0 noes.
The ayes prevail. House Bill 2563 as amended goes on to full judiciary.
Thank you so much.
Yes, sir. All right. Item number 5, House Bill 1737 will be rolled to the Hill. Item number 6, House Bill 2514 will be rolled to the Hill. Item number 7, House Bill 2317 by Representative Barrett. You have a motion, you have a second. You're recognized. There are 2 amendments. I'm guessing Amendment Code 16390 is the one you wish to.
That is correct, Mr. Chairman.
You have a second. You're recognized on the amendment. The amendment makes the bill.
That is correct, sir.
All right. Stop Amendment Code 16390 on the House Bill 2317. Those in favor say aye. Those opposed, the ayes prevail. You adopt on your bill as amended.
Thank you, Mr. Chairman. Members, research published in peer-reviewed scientific literature indicates that between 30% and 45% of child sexual abusers employ preparatory behavioral patterns, commonly referred to as grooming, prior to the commission of contact sexual offenses, and that nearly all adult survivors of child sexual abuse report having experienced such behaviors. The sexual grooming model in the Journal of Child Sexual Abuse represents the first empirically validated comprehensive model of the sexual grooming process, identifying 5 stages and 42 specific behaviors recognized by experts in the field as constituting sexual grooming tactics. The model has been further validated in subsequent peer-reviewed research, which identified specific red flag behaviors that are statistically and significantly more likely to occur in cases of child sexual abuse than in non-abusive adult-child interactions. Key findings of that research include that behaviors involving physical and psychological isolation of a child from parents or guardians were 20 times more likely to occur in cases of child sexual abuse. Behaviors designed to desensitize a child to sexual touch or sexual content were 34 times more likely to occur. And cultivation of secrecy between an adult and a child was statistically significant predictor of abuse. Existing Tennessee law, including TCA sections 3913-528 and 3913-529, effectively addresses the later stages of sexual grooming, specifically direct solicitation of a minor to engage in sexual conduct and the display of transmission of patently offensive sexual material to a minor. However, existing law does not address preparatory stages of grooming, specifically the deliberate pattern of access seeking, isolation, inappropriate physical boundary violations, and secrecy cultivation that the scientific literature identifies as precursors to contact offenses, and that may not rise to the level of conduct already criminalized under existing statutes. This bill seeks to fill the identified gap in existing law by criminalizing the preparatory pattern of grooming conduct that precedes and facilitates child sexual abuse without duplicating offenses already addressed in existing Tennessee law. And I ask for your favorable vote.
All right. Thank you for that explanation. I have Representative Powell on my list, but we have someone to testify. Do you mind to hold that? Okay. We'll go out of session without objection. to hear from Hope Beryl Green. If you would identify yourself for the record, you'll have 3 minutes for comments. We'll open it up for questions.
Good afternoon, Chairman, members of the committee. My name is Hope Beryl Green. I'm here today not as a policy expert, but as a survivor of child trafficking. I'm speaking because what happened to me should never happen to anyone. When I was a child, I was controlled, manipulated, and trafficked for 30 years of my life. Grooming is the doorway that predators use to gain control over children before the abuse and trafficking begins. It is calculated, patient, and deeply psychological. In essence, it's a form of mind control. By the time the physical crimes occur, the child has often already been conditioned to comply, to keep secrets, and to believe they have no way out. I want to thank Representative Jody Barrett for bringing this bill forward. And I also want to thank Michelle Peterson for her collaboration and advocacy on this issue across the country. If we want to stop trafficking, we must stop it before it starts. Trafficking begins with grooming. It begins with trust building, manipulation, gifts, attention, emotional dependency, and gradual boundary violations. Predators learn how to isolate their victims. They normalize inappropriate behavior long before anyone realizes what is happening. By the time law enforcement can act under many current statutes, the child has already been abused or trafficked. That is why a strong grooming law matters. It gives prosecutors a tool to hold offenders accountable before the child is destroyed by the next phase of exploitation. As someone who survived trafficking connected to Jeffrey Epstein network, I can tell you firsthand that trafficking operations rely heavily on grooming. Powerful predators rarely start with force. They start with manipulation and control. They start by making a child believe they are indebted. That manipulation is a trap. If Tennessee passes a strong legislation recognizing grooming as a crime against all minors under the age of 18, you will be taking a powerful step toward preventing trafficking before it happens. This is not about politics. This is about protecting children. Laws like this law send a clear message. Tennessee will not wait until a child is already trafficked or abused before acting. Tennessee will intervene when the grooming begins. As a survivor, I stand before you today asking you to close the gaps that predators rely on. Protect the children who cannot protect themselves. Thank you to everyone in Tennessee who do what they can each day to work tirelessly to protect our children, our most precious gift from God. And thank you to the members of the committee for listening and for taking this issue seriously, because every child we protect today is a life saved tomorrow. My prayer is that every captive will be set free.
Thank you very much. Questions for our guest, Representative Powell.
Yep, ma'am.
Oh, sorry.
Sorry. I just want to applaud your courageousness for coming up here and testifying. It's truly powerful. I guess, can you talk about how you, like your current situation, if you feel like you've gotten any sort of recourse or justice from what happened with you? And, I think you mentioned that this was tied to the Epstein.
Yeah, unfortunately, I'm sorry, I'm supposed to. Unfortunately, I went through a criminal and a civil suit, but didn't get any justice. My story actually came out in the files through DOJ recently around Christmas time. So I'm actually in the works of seeing what justice I can find through that.
Okay. Well, I wish you best of luck, and anything we can do to continue to open up all the files and make sure that everybody has access, and not to the victims, but to the perpetrators is really important. So thank you for your testimony.
Thank you for your support.
Anyone else for our guest? Seeing none, thank you for being with us and sharing that today. Members, we'll go back into session. First on my list is Representative Powell.
Thank you, Mr. Chairman. So question for the sponsor. Oftentimes, sometimes the victim themselves realize the abuse happened or that they were groomed even after they've into adulthood. So under this, and maybe this is a question for legal, but what is sort of the statute of limitations to bring this forward? And then also, just if you could just speak to that, how you see this moving forward, because a lot of times, because they've been groomed, they don't have, they don't realize they should share or have the ability to emotionally process it and share that information.
So I won't attempt to answer it because I don't want to get it wrong. I'll let legal address your question about the statute of limitations, but it will work similar to many other criminal offenses against the person that clock runs at the moment of discovery as to what has happened. So I'll let legal address that.
That objection, we'll go to session to hear from Legal Services.
So it's the statutes of limitations are by offense, and so this will be a new offense. So I don't think it's currently in the statute regarding sexual offenses that lists the specific offenses and a different statute of limitations. So until that is added, then it just applies under the general statute of limitations for the class of the offense. So for instance, one method of committing this offense is a Class B felony, and that statute of limitations is 8 years. Another way of committing this offense is a Class C felony, and that limitation is 4 years. And a Class D felony is also 4 years. So until it's specifically added to the statute that changes the statutes of limitations for sexual offenses, it would just be under the general.
A follow-up, if the grooming was occurring, say on an ongoing basis, and the bill becomes law, and the grooming continues, because I know you can't retroactively go back after a bill's passed, but let's say someone started grooming at the age of 12 and, we passed this, that person is now 15. Even though the grooming started before the bill passed, once the bill passes, the grooming charge can still be brought. Is that correct?
If it can be based on acts that occurred after the effective date of the act.
Okay, thank you.
Any other questions for legal while we're out of session? Seeing none, we'll go back into session. Representative Powell, you have all yours. Representative Salinas?
Yeah, I just want to say thank you for bringing this piece of legislation. Just last week, we found out about a labor leader that was grooming kids, and that person died, and the victims got no justice. And the victims now have to live with that. And we are just finding out about these things that happened in the 60s. I think the questions that Representative Powell asked are really important because oftentimes we don't find out about these things until later. So having something like this that can help us catch things earlier and have a course of action will hopefully prevent us from having more victims here in our state. So thank you for bringing this piece of legislation.
Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2317 as amended to full judiciary. Everyone voted. Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 2317 as amended moves on to full judiciary. Yes, sir.
If you'll indulge me, Chairman, everybody else has introduced their shadow today, and I think there's only one more remaining from Stewart County. And Karina, if you'll stand up so we can all wave. Thank you.
Absolutely. Yes, sir. You had another bill on the calendar. It wasn't calendared in the Senate, but we will roll that to the Hill in the event that you're able to get them to put it back on in Senate Judiciary today.
If you and I need to go over there and strong arm them, we can do that.
Thank you. Item number 8, House Bill 1525, Representative Stinnett. You're recognized. There are no amendments, so please proceed.
Thank you, Chairman, Committee. The only thing worse than victimizing a child is victimizing multiple children. In the code, there is nothing that specifies the sentencing of more than one child. So TCA 4035-115, HB 1525 would amend that with subsection E, and it reads, if the defendant is convicted of 2 or more offenses involving multiple victims who are minors under the age of 18 at the time of the commission of the offense, there is a presumption that the court should impose consecutive sentencing for each of these separate minor victims, unless evidence that of the fact of the case warrants not to be consecutive. So what this bill does is it gives the judge the opportunity or the ability, instead of, if you got 4 children, instead of sentencing this for 2 years, the judge could sentence this person to 8 years. I stand for questions.
Thank you for that explanation. Are there any questions for the sponsor? Seeing none, any objection to the question? Seeing none, all those in favor of sending House Bill 1525 on the full judiciary, vote aye. Has everyone voted? Anyone wish to change your vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 1525 moves on to full judiciary.
Thank you, Chairman.
You come up here for just a second, please.
Yes, sir.
Item number 9, House Bill 1769 by Chairman Clemens. You're recognized. There are no amendments.
No, sir.
Please proceed.
Thank you, Mr. Chairman and Committee. This bill before you today is the Intercollegiate Student Athlete Protection Act. What I'm seeking to do here is address the rising problem we have on college campuses that is posing a great risk and substantial harm to our student athletes who are playing in intercollegiate athletics. As sports wagering activity has become more widespread on college campuses and sports betting increases across the country, this is directly correlating and resulting in more harassment of student athletes based on their performance in intercollegiate athletic competitions. So what this bill seeks to do is protect students from that harassment. Harassment related to sports betting can cause serious harm to student athletes' mental health and well-being. As betting markets have increased, so is the prevalence of harassment, with 19% rates in men's basketball and football. 1 in 3 high-profile athletes receive abusive messages from someone with a betting interest. 90% of harassment is generated online or through social media. The NCAA has done a lot of research and put out a lot of data on this. They've done a lot of polling of student athletes. They found that 51% of Division I men's basketball student athletes reported receiving social media abuse based on their athletic performance. Interestingly, following the 2024 NCAA Women's Basketball Championships this time of year during March Madness, women's basketball student athletes received approximately 3 times more threats than men basketball players, which was pretty fascinating. And, you know, when we talk a lot about protecting women athletes, this is certainly something which we should be concerned with. There's ample data. NCAA, like I said, has been doing a lot of work on this, seeking how to address this issue. The way that I've chosen to approach and address this issue is with this piece of legislation, and it's narrowly tailored to protect the student athletes under certain circumstances where there is intent proven, where a reasonable person would perceive communications to be a threat of harm. So we really try to thread the needle here and make this narrowly tailored. And it also gives student athletes the ability to have a private right of action if they're receiving this from individuals. And at the end of the day, this is about protecting students. Most of these student athletes between the ages of 22, these are young people who should not be the subject of harassment just based on their athletic performance. And so that's what I'm seeking to do. And I ask your support for this.
Questions for the sponsor? Leader Lambert.
Thank you, Mr. Chairman. And Chairman, I know we've talked a little bit about this before, but obviously I deeply value the First Amendment and folks' ability to be able to speak their mind in this country. I don't want to live in countries like what the UK is going through right now, where some sports fan, I'm a UT fan, I'm a Vols fan, gets excited online about a missed kick or a throw that went awry or something like that, and spouts off on Twitter about something, and then some student athlete reads that or family member, and look, I don't think you should be spouting off like that. I don't like half the stuff that people say online about you or I, but it's their right to say it. And so a bill like this that would equate popping off online like that to an e-felony, a DUI fourth offense is an e-felony. Theft over $1,000 is an e-felony. I mean, to put it to that level, and then on top of that, allow for civil penalties where, I mean, a minimum $75,000 statutory damages with actual damages, punitives, equitable relief, reasonable costs and attorney's fees. I mean, look, it's a sledgehammer. There's no doubt about it. I mean, this is a bill that will shut down, in large part, a lot of conversation online. And I don't think that's what you intend, but I think that's what it's going to have, is a significant chilling effect on the First Amendment. So folks get excited about sports. Thank goodness, based to Tennessee's leadership and other states, but specifically Tennessee, student athletes are now paid, and paid very well, for their efforts. Used to, that didn't happen, but they do. They are very public figures now. Again, just as you and I are. With that comes a certain amount of protection, I think, that they can put around themselves so that they're not reading all these crazy comments that people put in. But people have a right to say things that are sometimes outside of what you and I would feel comfortable in this country because of the First Amendment. So I respect what you're trying to do here. It does feel like it is way overkill for comments that are made online with making it an e-felony and a misdemeanor. I mean, an a misdemeanor is, again, DUI, domestic assault, theft. I mean, it just seems like for somebody who may have popped off online about a missed field goal, and people get very excited about sports. I'm glad that they get into sports, because what that does, they buy tickets. It helps, universities raise money. It, quite frankly, helps pay these student athletes, and many of them will make more money in their collegiate career than they might make in their chosen field after college. With that does come a certain amount of, bad comments that may be made, but I trust that they can handle it. I've met a lot of these players. They know that it's a crazy world out there, but that the First Amendment is alive and well in the state of Tennessee and in the country, in our country. And I just don't think we should squelch it. So again, I know that's not your intention, but that is my concern, that it does seem to be a sledgehammer toward what is a niche problem that, quite frankly, when I see stuff like that online, I've popped back off on people that have gone over the line on a student athlete. I've seen coaches do it. I've seen fans do it. I think within the bounds of the First Amendment, we can make sure that we shame the heck out of somebody who's trying to just harass some kid online with their social media comments. I don't think we need to put them in prison for 1 to 6 years. That's just my opinion.
Mr. Chairman, thank you. Yeah, so look, we all hate Alabama, right? So, except by so I appreciate your concerns about First Amendment. So with regards to the First Amendment protections, that's why I've narrowly tailored this. Even if you were to review this under strict scrutiny standard and consider this some sort of content-based restriction, I'm not sure that fandom equals a viewpoint. There's certainly a compelling state interest in protecting the safety of our student athletes. The reality is most student athletes are not paid. Now, we all think of student athletes now as the biggest football player, quarterback getting $4 million. Sports betting and the harassment is involving people performing, and competing in fencing, people playing D3 soccer, people, these student athletes playing this wide range of sports who you may never even read about or hear about, but they're being directly harassed and threatened based on sports betting markets that involve all these sports you never heard about. Look, I was a rower in college. We weren't the focus of anybody's attention, but once upon a time, rowing was the biggest betting sport in the country, right? And so now people are betting on it again, but those athletes aren't being paid. So I just want to make sure we're thinking broader here on a macro scale, that this isn't just about those student athletes who are being paid. This is about a lot of children and our children who are playing college athletics that we're seeking to protect. Now, with regards to the strict scrutiny, I think we overcome that pretty easily, even if you consider fandom a viewpoint or a content-based regulation or restriction. This has been narrowly tailored, as I said in my opening comments. If you look at the definitions here, the hurdles that we're talking about, you've got a communication of a threat that's related to the performance of that student athlete in that sport that intends the communication to be a threat of harm, and a reasonable person would perceive that communication to be a threat of harm, or they engage in sports-related bullying or cyberbullying, which are also clearly defined in this bill with a high hurdle of proof, intended to harm, intimidate, or humiliate, repeated over time, and causes the student athlete to suffer emotional distress, and a whole list of things here. So while I appreciate the concern, even if it did rise to the level of scrutiny, which I doubt it would, I'd probably be more in intermediate scrutiny, I would assume, time, place, and manner type of restriction. I think we overcome that First Amendment hurdle. And again, this isn't seeking to limit someone from yelling at a football player or something like that. This is a very specific type of communication that is threatening harm to a student that's directly aimed at that student. This isn't just a chat room or something of that nature. This is something that's directly targeted, communicated at that student, to that student, with specific intent that a reasonable person would hold. So I think I've done the best possible job in working with legal in structuring this legislation to be narrowly tailored, even if it rose to that level of scrutiny. For that very purpose, I do think we all need to be, whether this passes today or not, I think we all need to be acutely aware of what is happening on our college campuses. This is a huge concern of athletic directors across the country, across the state of Tennessee. Like I said, NCAA is focused on this because it is such a threat to the children who are participating in sports. That gives them opportunity to get an education, that gives them an opportunity to stay out of trouble in some instances, and provides them with life skills and certain life lessons that have benefited us all in our professional lives. So that's what the bill seeks to do, Mr. Chairman. I think we overcome any First Amendment challenges, and I think I've narrowly tailored it to be specific for the intent stated and to get reasonable governmental interest here with least restrictive means.
Leader Lamert.
Thank you, Mr. Chairman, and I appreciate that rebuttal. And we found some common ground, if nothing else. I spent a couple of years rowing crew at UT as well. Though the ladies were the varsity squad, we were just the intramural squad, and we're tickled to be down there in the boathouse and get whatever boats they weren't interested in using anymore. But look, whether it's rowing crew or football or fencing or basketball, I just deeply value our civil liberties. And whether you win this one in court or not, I think in Tennessee, you have a right to say about whatever you want to, especially online. And again, I value that right. I know you do as well. With criminal penalties and civil penalties, again, I understand what you're trying to do here. And I don't think anybody should be out there trying to harass players, but harassment's already illegal. You can already sue somebody, but a $75,000 statutory damage plus attorney's fees and everything else, it just seems a bit much for me at this moment. With that, Mr. Chairman, I would move that we summer study this, and I hope we genuinely do look at it.
Second.
There's been a motion for a summer study. There is objection. So we'll be voting on the summer study motion. It'll be on the board. Those in favor of the summer study motion will vote aye. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 6 ayes and 2 noes.
The ayes prevail. House Bill 1769 will be moved to a summer study.
Thank you, Mr. Chairman and committee.
Yes, sir. Representative Powell.
I'm good. I had a question on the bill, but.
Oh, okay.
Thanks.
Sorry. Item number 10, House Bill 931 by Representative Towns, was general subbed in the Senate, so we will roll this to final calendar number 3. Let's jump to item 12, House Bill 2296 by Representative Hardaway. Representative, would you like to sit at the table over here to present your bill?
No, sir, I'm fine.
Okay, well, you're recognized.
House Bill 2296, Mr. Chairman, is one of many bills that we talk about quite often. It brings a balance between defendant rights and the actual alleged victims. It speaks to the rights of the defendant to access bond. However, it makes one of those conditions GPS monitoring. And that's for the protection of both the victim and for the defendant. With that, I'll ask for a motion and a favorable vote.
Well, you've got your motion in second, sir, but we have Leader Lamberth on the list.
Representative Hardaway, we obviously hail from different parts of the states and different parties, but we've worked together for 14 years now and have worked to try to have bills that improve public safety. I appreciate you bringing another bill that looks to me like that it would improve public safety and balance those rights that you've listed of the accused and everyone involved in the system. So I'll certainly be supporting your bill. As I have many before, and we have a lot of conversations in the off season. We disagree on many things, but we try to do so in an agreeable fashion. And I know you come from a place where you want to make sure that your community is safer, and mine is as well. So just want to speak support for the bill, and appreciate your service down here, even though, again, we disagree on a great many things, politically speaking, but we both share a deep zeal for community safety. So thank you.
Thank you, Mr. Chairman. I hate Alabama.
If I didn't love you, I'd almost roll you to the hill, GA. Any positive things from the committee to be said here? Representative Powell?
On the bill.
Question's been called. Any objections? Seeing none, we're voting to send House Bill 2296 to full judiciary. Everyone voted. Anyone wish to change your vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 2296 moves on to full judiciary.
Thank you, committee.
Representative Hardaway, you had a couple more bills that were on the calendar. Do you wish us to take them off notice?
Yes, sir.
Okay. Item number 11, House Bill 1064 by Representative Hardaway, will move to final calendar number 3. Item 13, House Bill 2298 by Representative Hardaway, be off notice. Representative Powell.
We're at a standstill here, and Lita Lambert's out of the room and Chairman Clemens is out of the room. I was wondering if it'd be harassment if I created a meme of them rowing together. It's maybe a question for legal.
We'd all like to see it.
We would go to number 16, but there's an amendment. Well, here he comes. So we can. Item 14, House Bill 944 by Representative Mitchell will be rolled to the hill. Item 15, House Bill 1058 by Representative Mitchell, rolled to the hill. Brings up item 16, House Bill 1441 by Representative Brooks. You're recognized. There is an amendment code 13677. There is a proper motion and second. That amendment is by Leader Lambert.
Motion.
So, yeah, you're recognized.
Thank you, Mr. Chairman. Stand ready for questions.
Questions on the amendment for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to adopt Amendment Code 13677 on the House Bill 1441. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. You adopt. We're on the bill as amended. Representative Brooks.
On the amendment, I don't know, the amendment will change the direction of the bill or the intent of the bill.
Leader Lambert.
Mr. Chairman, I didn't go in deep and explain the amendment because I talked to the sponsor beforehand. Without the amendment, the bill does nothing. I mean, it doesn't add any criminal penalty. With the amendment, it makes sure that if you're an officer, if you criminally impersonate an officer and commit a crime, then it makes it consecutive to the underlying crime. Without the amendment, the bill has a not significant fiscal note because it literally, I mean, with all due respect, doesn't do anything. They're going to be convicted of the underlying crime, and the criminal impersonation will just be dismissed in virtually every single instance because you'll have a more significant crime underlying the criminal impersonation. And I know we had discussed this. I did not realize you had any objections to the amendment and still don't know. But I mean, with the amendment, it makes it where the criminal impersonation is consecutive to. So anyways, that's why I tendered the amendment so that the bill actually does something.
And I get that. I don't have a problem with it being consecutive. I just have a problem with it being changed from violent crime to whatever the amendment says.
Leader Lambert.
Yes, sir, Mr. Chairman. It, again, includes any criminal offense. So you didn't like that aspect of the amendment, that it's consecutive to any criminal offense?
I don't want it to cover, I don't want it to be a blanket. I don't want it to cover.
Leader Lambert.
Mr. Chairman, I didn't know the sponsor of the bill had an issue with it. Moved to roll to the hill. I'll be happy to talk to the sponsor about it. The intention was to strengthen the bill, but I don't want to do something the sponsor doesn't like. So, I mean,
It's just
I
one
move
part
that
of.
we roll this to the hill.
All right, so we'll roll this bill without objection. House Bill 1441 be rolled to the hill. All right, now we're on, let's tell you what we'll do. We'll skip down to item number 20, House Bill 2139. Speaker Marsh, you recognize there's Amendment Code 14873.
Correct. That's correct.
You want to proceed with that amendment?
Yes, please.
All right, you recognized on the amendment. Does the amendment make the bill?
Yes.
All right. Any objection to the question on the amendment? Seeing none, we're voting to adopt Amendment Code 14873 on the House Bill 2139. Those in favor say aye. Those opposed, the ayes prevail. You adopt. We're on your bill as amended.
Thank you, Mr. Chairman, members. Cargo theft is a big problem in Tennessee, and if I'm not mistaken, I believe Memphis is one of the top, if not the top cities in the nation with cargo theft problems. We're having it in trucking transportation as in rail transportation. And this bill
formally standardizes reporting and investigation procedures for freight theft carried out through fraud or deception, helping law enforcement and the freight industry better track and prosecute these crimes. What we're getting at here is if there's a rail car loaded in Memphis and they find out in Los Angeles when it gets there that it's been stolen or partially stolen, now there's really no way to get a report filed that you can turn into your insurance company. So what we're saying in this is a reporting standardization area set up where you can fill out the paperwork. You can come back to the law enforcement in Memphis and let them fill out the paperwork so you can get a report to turn into your insurance company. That's basically what it does. I'm answering any questions.
Questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 2139 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 9 ayes and 0 noes.
The ayes prevail. House Bill 2139 as amended moves on to full judiciary.
Thank you, Mr. Chairman.
Thank you. Let's pick up, let's see, item number 33, Representative Dixie. This bill was subbed in the Senate.
Since it's up for on the 23rd, so I don't know when it was.
House Bill 2229 was assigned to the General Subcommittee of the Senate Judiciary Committee yesterday.
Yes,
Or
sir.
on the 23rd, I'm sorry.
All right. Well, I did have someone that come to want to testify on this bill. I would like to give them a chance to at least talk about it. So maybe if we bring it up next year, you'll be familiar with it, and maybe we can get it done then, if that's the will of the committee.
Okay, it was a late submission, so we received that submission after the deadline for submission for testimony. So, Representative Salinas.
I know that we're meeting this afternoon. If this bill's rolled to the afternoon, would it make it timely submission?
It will be the same calendar, so no, it would
Okay,
not.
thank you.
So,
All right, well, and since it's been gen sub, it's not going anywhere anyway. So, and when I looked it up, it didn't say that. So,
Leader Lambert.
And I just checked it again, and the chairman, as always, is right. It was gen subbed over there. I will tell you, if your guest is here, even though they're not on the list, I think several of us do have some time in our offices today and different gaps in the schedule. I, for one, would like to hear from them if they want to reach out to my office and come by. I'd like to hear from your guest on this bill. And I know other members, I'm sure, would as well if they're not in committee. And so I know we have a lot of committee time today, but I know there are a couple of gaps on my schedule. So whoever the witness is, if they want to swing by offices and have that one-on-one conversation, that might even be more helpful than even testimony here, especially if we're talking about a bill potentially for next year. So
I appreciate that sentiment. And this is it's a special bill because it was written by inmates. It was written by inmates, and it's written by somebody that's actually it's impacted by this. So that's why I think it's very important. So I would be very appreciative if the leadership would take this meeting, the chairman would take these meetings.
All right, do you want to take this bill off notice? If it's
Yes,
General Sub, that objection, House Bill 2229 will be off notice. Item number 34, House Bill 2232 by Representative Dixie. I'll give you a second there. You do have, there's no amendments, so
No.
please proceed.
All right, thank you. All right. So this bill sets out how a person can petition a court to expunge a criminal history record when certain eligibility conditions are met. It's one of the core parts of Well, it's been done in a couple states, Florida and Pennsylvania already. So this bill promotes public safety, personal responsibility, and economic opportunity by allowing rehabilitated individuals to seal certain low-level criminal records without compromising law enforcement access or community safety. Accountability is required before relief. Record sealing is not automatic. Individuals must complete all terms of their sentence, pay all fines, restitution, and court costs, remain crime-free for at least 5 years, have no pending criminal charges, and ensures that the relief is available only to those who have demonstrated sustained law-abiding behavior. Public safety protections remain intact. Seal records are still accessible by public safety purpose. Firearm background checks, handgun carry permits, health department registries or for involving abuse or neglect of vulnerable individuals, and law enforcement agencies do not lose their visibility where it matters the most. Serious high-risk offenses are excluded. This bill explicitly excludes domestic assault and DUIs, driving under influence. Only misdemeanor offenses and pre-1989 offenses that will be misdemeanors today are eligible. This maintains strong protections for public safety and victims. There is someone who wanted to speak on this, and hopefully they got everything in timely.
Kiana Brown. Let's go out of session. We'll hear from our guest. If you will, please introduce yourself for the record, and you'll have 3 minutes for comments. You don't have to touch anything. We've got it. Your light is on, so just pull the microphone down and
Hello, thank you, Mr. Chairman. My name is Kiana Brown, and I'm the president of the Tennessee Women's Chamber of Commerce, the organization that I had founded a few years ago, and I'm just now revamping it back, but I am in full support of this bill of sealing the misdemeanor records because people deserve a real chance to move forward after they made a mistake. A misdemeanor can follow someone for years, showing up on background checks for jobs, housing, and education, even when the offense was minor or happened long ago. That record can continue to close doors and limit opportunities. Sealing misdemeanor records don't erase accountability. Individuals have already gone through the legal process, completed their sentence, and paid their debt to society. What it does is recognize growth and allow people to rebuild their lives without a permanent barrier standing in their way. When we allow people to move beyond past mistakes, our communities become stronger. People are more likely to find stable employment, secure housing, and support their families. That stability reduces repeat offenses and helps individuals become productive members of society. Supporting the sealing of misdemeanor records is about fairness, second chances, and strengthening our communities. Everyone benefits when people who have learned from their past are given the opportunity to move forward. And I myself am a witness to that. It's been over 2 decades since I have, been in trouble. I do recognize my past mistakes, and I am a recidivised citizen, and I have paid my debts to society. So I feel even if it's a big step to at least let people move forward, to give them at least a second chance. It has altered me in several ways to become an entrepreneur, but also I'm a lobbyist as well. Lobbying for the Women's Chamber, and just here to, create synergistic relationships that allow people to connect, protect, and serve our communities in the great state of Tennessee.
Okay. All right. What are we?
If anyone has any questions.
Thank you. And thank you for that. Members, do we have any questions for our guests? Okay, very good. Representative Salinas, you recognize.
I know you've come by my office and we've had an opportunity to talk.
Absolutely.
So I just wanted to let you know publicly on the record that I'm really proud of you and proud of the changes that you have made and how you're using your story not to only help yourself. I remember we talked how you became an entrepreneur because you couldn't get hired.
Absolutely.
And then went on to try to help other people start their own businesses as an option for them to have a job. So I just wanted to let you know I'm proud of you.
Thank you.
And next, Representative Powell, you recognize.
Thank you. Too, appreciate you coming up here and giving your testimony. I think it's very important that people, oftentimes are hindered by having, even small infractions on the record, and those that honestly disclose those sometimes can be punished, and other people will not and try to hide those. And so anytime that we can help people try to avoid the trap of recidivism, because they might not be able to find a work or be hired because someone has, does a search or looks, or it's disclosed on the application about a prior, even small blemish on their record. And so to help others be able to find work through this bill, making it so that we can expunge those different types of offenses, I think is really commendable and will help a lot of people. And actually, I'd say this is a very positive thing, and almost a positive fiscal notice, because it keeps more people out of the system because they're able to find meaningful employment and not fall into the trap of recidivism. So thank you.
Yes, sir. It also helps the economic development of individuals and the state as well. 13 other states have enacted the Clean Slate program, and I know we're not there yet, but if we can be the 14th or the 15th state to be able to be given second chances, I think that would be allowable to let people know just because you have had a record or it doesn't define who you are.
That's right.
Very good. Any follow-up?
No, and I disagree with our governor about a lot of things, but I know Governor Lee, he does believe in giving people a second chance and working and mentorship programs and others for people. So I think this fits in line with a lot of his things that he's trying to accomplish as governor. So thank you.
You're right, he does, and I'm in the process of waiting on my pardon. I applied for a pardon application, so I'm just waiting on the call any day.
Right. Very good. President Bill, any follow-up? All right, Leader Lambert, you recognize. Okay, he waves off. I want to hand this back to Chairman Doggett.
Any other questions for our guest? Seeing none, thank you for being with us today. I have on my list a Graham Tudor and a Ryan Byard. If you two were, you can leave the table if you want to. Yes, ma'am. If you two will identify yourself for the record, you'll have 3 minutes for comments.
Good morning, Chairman and committee members. My name is Graham Tudor. I am the Director of Legislation for the Tennessee Department of Safety.
Good morning, members. My name is Ryan Baird. I'm the Assistant Director for the Department of Safety.
I'd first like to start, Representative Dixie, I'm sorry I didn't get to stop by your office and let you know our concerns. But I want to express the Department of Safety has some concerns here with this legislation. Specifically, federal regulations prohibit states from masking a CDL holder who has a conviction for any violation in any type of vehicle, whether it's their commercial motor vehicle or their personal motor vehicle, of a state or local traffic control law. If states do not comply with the anti-masking statute, they do risk losing federal road money. So that's specifically the concerns of the Department of Safety. Happy to answer any questions.
Questions for our guest? Representative Powell.
So a question for you. So if we're able to amend out those traffic violations, then would you have any concerns about the bill?
No, if we had a chance to amend those out, I think we could become comfortable.
Okay, thank you.
Any other questions for our guest? Seeing none, thank you both for being here. We'll go back in session. Representative Dixie.
All right. Thank you. I appreciate it. I do find it a little offensive that you didn't come talk to me beforehand, because that to get this information right beforehand is something that we could have talked about before. But I wish that, hopefully it won't happen again. And hopefully I'll move up the rankings to be a little bit more important to get by and see. But I also wanted to say that, this bill creates strong incentives for law-abiding citizens. And if a person is charged with a new offense, sealed records are immediately unsealed, and if convicted, they're permanently revoked.
This will help support Tennessee's workforce and economy. Criminal records are a major barrier to employment, housing, and professional license, as we heard the young lady testify. And this will help individuals with low skill record to expand Tennessee's labor workforce, reduce dependency on public assistance, and increase tax contributions. This is a cost-neutral, user-funded process. No new state funding is required. Clerk's offices are compensated for processing the provisions, but I feel like this is a good bill. That's a stepping stone to get people back on their way to their citizenship. So I would ask for your vote for this, and hopefully, if there's some issues or something that we can work out, we can work on it between here and full.
Right, Leader Lamberth.
Thank you, Mr. Chairman, and I don't know what you've got going with the departments. They've been very good to work with, but everybody's busy this time of year. So I don't think they meant that it's some sort of barb at you, but obviously I'll let y'all work that out. But I appreciated their testimony. I do have a question about the last section, and I mentioned that to you. I don't know how a judge would know to rescind an offense. Like if a new offense happens after this is shielded, how a judge, say in Sumner County, if somebody committed an offense in Davidson County, would even know. So I don't think it's something that is just irreparable, but I will move at this time for this to go to the afternoon calendar today. Same calendar, same day. We take this up this afternoon. I'd like to get with legal and just kind of see if there's some sort of a notice requirement we can put in there or something, because it says shall rescind in that last section. And if a judge is required to rescind something, I don't know how they would rescind it if, say, the new charge happened in Knox County and the judge is in Sumner County or any other county in the state, or quite frankly, in another state. So when we put that it shall rescind, I understand, and we were talking there at the podium, but it's requiring the judge to do something they may not even know about. And so with that, Mr. Chairman, again, I would move this to this afternoon's calendar or however we wish to do that.
Representative Dixie.
No, I understand your concern, but I think that one of the things they could do would be an NCIC. A lot of these things, so that covers the entire United States. And you have the TBI, and these are state charges. So, other states may not be able to, it's like say there's only 13 states that have this program available. So even if someone caught another charge in another state, I think that they should be able to find that, or they should be able to know that, especially if it happens in Tennessee.
All right, Leader Lamberth.
And also, I'm sorry, but the reason why I put that in there was 'cause I just want to make sure that people were held accountable. And if they did do something, you have something to lose in case you were arrested again. So this is not a get out of jail free over and over, and you can do it. This is a one-time, do right, and it will help you change your life.
Leader Lamberth.
Again, judges can't just sit in their office and check NCIC every day to see. I mean, over time, these will build up. I mean, there may be hundreds, thousands, or tens of thousands that a judge has signed. They can't just be sitting there on NCIC searching people's criminal histories because they wonder whether they've gotten. There has to be some sort of a mechanism that there's notification. And I know you work within this system. I know what you do for a living. You understand what I'm saying. I mean, a judge doesn't have the authority to just check NCIC and say, well, I wonder if fill in the blank person got arrested last week. I mean, they're just not allowed to do that. Now, again, within their own clerk system, in Davidson County, it'd be pretty easy probably to say, oh, I remember you. You were here just last month and got this shielded. So again, Mr. Chairman, I've made a motion. I mean, I just think it's close, but it's not quite there. I'm not recommending that we move it to next year or anything else. I just think the department brought up some good concerns with it. And I think logistically, the last part of it, I think the reasoning is good there, but the mechanism of it is impossible.
All right, thank you. Representative Powell.
Thank you, Mr. Chairman. I was going to add, and I'm fine to move this to the afternoon, that maybe you could get together with the department, or rather the department can get together with you, and maybe you can come up with some amendment language as well, so that we could not risk the federal funding for the roads. So, but yeah, I'm fine to second the move to this afternoon's calendar.
Oh, thank you, Mr. Chairman. I appreciate it, and I'm fine with that. I just say if it's been done in 13 other states, we're not recreating the wheel here. Let's just figure out how we can work together to make this happen to help other people, other Tennesseans' lives better. So thank you. I appreciate the opportunity to work with the department and try to make this a better bill.
Thank you. And I think this would be another major push for a unified or united court system across the state, because that's something that we do not have currently. So, We will, what we're going to do is we'll roll you to the Hill. It'll be in the afternoon session when we get to 3 o'clock.
All right.
Okay. Without objection, roll to the Hill.
All right. Thank you.
Chairman Halsey? Trying to find what bill
Thank you.
number, what's your bill number there, Chairman Halsey?
2608.
2608. Item number 29. Now this, you have a motion second. This bill was general subbed in the Senate.
Yes, sir. And I know that were it to be heard in this committee, it would skyrocket right straight through with great accolades. And so I'm not going to get a chance to present the whole bill. You did allow me just a second to make a comment about it, and then I will take it off notice. I'm going to go away, but I don't think this issue is going to go away at all. Folks are bothered by it quite a bit. And I know police absolutely love it, love my bill. And I just wanted to make a couple of comments to plant in your mind, and then I will be through. I want to read you an interesting statement by the former Supreme Court Judge William Brennan. I thought that was really good. He says, while the machinery of law enforcement and indeed the nature of crime itself have changed dramatically since the Fourth Amendment became part of the nation's fundamental law in 1791, what the framers understood then remains true today, that the task of combating crime and convicting the guilty will in every era seem of such critical and pressing concern that we may be lured by the temptations of expediency into forsaking our commitment to protecting individual liberty and privacy. I think it's a great statement. And the biggest issue I heard from police about this was the Fourth Amendment requirement. I still do believe anytime you look backwards and harvest data with the purpose of establishing probable cause or using for evidence to convict somebody, I do think it needs a Fourth Amendment protection on it. It's interesting to me, I've been told several times that you don't have an expectation of privacy driving down the road, and I suspect the tag on the back of my car doesn't. But when you can harvest enough data to establish a profile for me, where I go, how long I stay, the routes I take, then I do think I have an expectation of privacy. One other point, it was interesting to me that 5 years ago, we passed on this House floor a bill that said it was criminal to put a tracking device on another car over the issue of expectation of privacy on where you drove down the road. I said this in another committee, and this will be the last thing I say. As constitutional principle wanes, I think you will find that tyranny becomes casual, and we will become accustomed to it. Those things bother me a great deal. I appreciate your patience with me, and I will move to take this bill off notice.
Thank you for that. Leader Lamberth.
I would object to that, but I understand where the posture of the bill is. But Representative Halsey, you filled a lot of roles down here in the legislature, and I spent months and months trying to convince you to run again. And I respect the fact, just like I do some of my other friends, that you're not going to. But issues like this, and quite frankly, presentations like that, are why you will be sorely missed in this chamber. You have brought issues to the forefront that other folks sometimes ridiculed or poked fun at you for. They've tried to emulate your speaking voice and tone, some even in this room. I think they even put you on a t-shirt at some point or another. But you've been an absolute treasure for this state, and you will be sorely missed in your retirement. It is well earned to retire from this chamber. But I, for one, will always keep an open door. And I hope anybody that ever serves down in the legislature will keep an open door to both your ideas, your personality, your passion, and just the amazing person that you are. So thank you for your service to the state.
I appreciate that so much. Thank you. Thank you, committee.
House Bill 2608 will be off notice. Let's go to item number 21. House Bill 1317 by Leader Lamberth. You recognize Amendment Code 14109.
Yes.
You have a second on the amendment. You're recognized.
Yes, sir, Mr. Chairman, and it is a short amendment, but it makes the bill. This just fixes a glitch in the system that I'm sure some of these officers over here are aware of. Cases sometimes will get continued on and on because the current law requires that if someone has to do jail time for a DUI, it has to be served within 30 days of their plea. This would just relinquish that and say that it has to be served at some period of time during their sentence. So if it's day 31 or if it's day 60, as long as the person comes in and actually serves their jail time, that's between them and the judge and the sheriff and the jail. That's what the amendment does, Mr. Chairman.
Any questions for the sponsor on the amendment? Seeing none, any objection to the question on the amendment? Seeing none, we're voting to adopt Amendment Code 14109 on the House Bill 1317. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You adopt or on your bill as amended. Any additional questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1317 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 9 ayes and 0 noes.
The ayes prevail. House Bill 1317 as amended moves on to full judiciary. Representative Sherrill, come on up. We're going to go to item number 62. You have a motion and second on item House Bill 2221. So you are recognized.
Thank you, Chairman. Have amendment 014509.
Wait a minute, give me that code one more time, sir.
Yes, sir. 014509.
All right, you have a motion and a second on the amendment. You're recognized on the amendment.
4 years ago, we passed a bill creating a criminal proceeding notification system under the Sheriff's Association. The system lets a victim register anonymous once the offender is booked and allows them to receive notifications as their case processes through the court system. This November, the voters will likely adopt Murphy's Law into the Tennessee Constitution. The criminal proceedings notification system is necessary to comply with the Murphy's Law, as our Constitution will soon mandate that the victims have the right to notifications throughout the court process. The notification system only works if the data is there for the criminal court clerks. This bill mandates that clerks will make the application data available to the TSA, which is the Tennessee Sheriff's Association, for the administration for the criminal procedures notification system. We have 86 counties that are currently participating in the program, and this bill will help get the remaining counties on the system, and that's pretty well what it'll do.
Well, very good. Any questions for our sponsor? We are on the amendment. All right, any objection to the question on the amendment? Seeing none, we're voting to adopt Amendment Code 14509 on the House Bill 2221. All those in favor say aye. Those opposed, ayes prevail. You adopt. You've basically explained the bill already, sir.
Yes, sir.
Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2221 as amended on the full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 2221 as amended moves on to full judiciary.
Thank you, Chairman and Committee, for taking me out of order.
Yes, sir. Thank you. Item 17, House Bill 1967 by Chairman Farmer. Are you ready?
Yes, Mr. Chairman.
Well, you're recognized. There's Amendment Code 13357. You wish to proceed?
That's it. Yes.
All right. You have a motion and a second. You're recognized.
Very good, Mr. Chair. Members, what this bill does, it's right now leaving the scene of the accident is a Class E felony. And what this bill would do that is a Class E, so that's what, let's see, 2 to 4 years-ish at the range, one offender. If you leave the scene of the accident that has resulted in a death, this is going to increase that punishment to no less than 1 year confinement. You have to serve 100% of that. And then a mandatory fine no less than $5,000, no more than $10,000. So if you leave the scene of an accident has resulted in a death, it's going to increase that penalty. And that's what this bill does.
Any questions on the amendment, Representative Powell?
Question for the sponsor. I know there's a similar bill. Could you speak to how these will work together or not work together?
Chairman?
I would if I knew the language of the other bill. I don't know which bill it is.
Okay.
We may ask legal. Legal may know.
We can go out of session here from Legal Services?
If we could.
We're out of session.
Michelle Fogarty, Legal Services. I believe the other bill raises the penalty to a Class D felony. This bill keeps it as a Class E, but requires a mandatory 1 year term of imprisonment.
It's not yours. Okay. So a little bit different. Mine's an E, so that's 1 to 2 years. The D is 2 to 4. But this result in just that minimum mandatory 1 year. So I'd say they're a little bit different-ish.
Yeah, they're different.
Okay. And I've got a significant fiscal note we're going to have to tackle. I believe, well, actually, no, it's only $10,000. I just asked for passage.
Okay. We're still out of session. Representative Salinas.
Thank you, Chairman. If I remember correctly, the last bill didn't have a fine associated with it. Is that correct? Am I remembering correctly?
Members, while we're out of session, and I want to recognize Sheriff of Lincoln County, Tom Malone, just walked in the room. He's here with Lincoln County. He's got a special day on the Hill, in case you did not know. Good to have you with us. Legal Services, you're recognized.
Michelle Fogarty, Legal Services. The other bill just has a standard, it's a Class D felony with a standard fine, which is up to $5,000.
Okay, so this one has a higher. Okay, thank you.
Representative Powell, you got anything else for legal?
No, I just talked to the sponsor of the bill. I think, I'm fine to move this out. Maybe they can get together and work it out.
All right. Anything else for legal while we're out of session? Seeing that we're going back into session. Chairman Farmer.
Let's move passage.
All right. All right, we're still on the amendment, so any objection to the question of adopting Amendment Code 13357 on the House Bill 1967? Seeing none, we're now voting to adopt such. All those in favor say aye. Those opposed, the ayes prevail. You adopt. We're on your bill as amended. You've explained the bill. Any questions for the sponsor on the bill as amended? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1967 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 9 ayes and 0 noes.
The ayes prevail. House Bill 1967 as amended moves on to full judiciary. Item number 19, House Bill 1268 by Representative Scarborough. You are motion and second. You're recognized. Amendment Code 13605. You wish to proceed with that?
I do, sir.
Motion amendment.
Also have
You got a second on that? There's another amendment.
I do. 16071.
Motion on the second.
Well, hang on. Hang tight before we.
Withdraw.
I never got a second one.
016071.
Never filed. Wasn't filed with us. Doesn't exist.
I rolled this afternoon, sir.
Absolutely. We'll roll to the Hill. Representative Eldridge. Okay, it failed in the Senate. Did he? Item 23, House Bill 989 failed in the Senate. Without objection, we will take this off notice. Without objection, off notice. Item number 26, House Bill 723 will be rolled to the Hill. Item 27, House Bill 2321, rolled to the Hill. Item number 30, House Bill 2062 by Representative Towns. Roll that to the Hill. Item 31, House Bill 626 by Representative Hardaway will be off notice. Item 32, House Bill 2301 by Representative Freeman, roll to the Hill. Takes us to item number 35, House Bill 1787 by Chair Lady Littleton. You recognize Amendment Code 13812. You wish to proceed with that?
Yes, I do.
All right. You are recognized on the amendment.
Thank you, Mr. Chairman. This increases the penalty for patronizing prostitution from a law enforcement officer 18 years of age or older posing as a minor from a Class C A misdemeanor to a Class B felony, and establishes the patronizing prostitution from a person who has intellectual disability and a Class B felony and is no longer punishable as trafficking for commercial sex acts. Establishes that patronizing from a person who is 18 years of age is a Class A felony and is no longer punishable as trafficking for a commercial sex act.
That is the amendment. Questions on the amendment? Seeing none. Any objection to the question? Seeing none, we're voting to adopt Amendment Code 13812 on the House Bill 1787. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You adopt or own your bill as amended. Questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 1787 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes, 0 noes, and 2 present not voting.
The ayes prevail. House Bill 1787 as amended moves on to full judiciary. Item number 36, House Bill 2001 by Representative Powell.
Thank you, Mr. Chairman. So given respect for the committee, this bill was taken off notice in the Senate yesterday. So they had some very good testimony. There was a few just little minor things that need to be still worked on this bill pertaining to making sure that some of these medications that you are actually in your system and they're active for a given amount of time. So with that being said, we're still working on this bill, but I'm going to go ahead and take it off notice for the session. Thank you.
All right. Thank you for that. House Bill 2001 will be off notice. Item number 37, House Bill 2209 by Representative Powell.
Thank you, Mr. Chairman. Again, same thing in the Senate. I know I've been on the calendar here for a while, but the Senate caught up to us. This bill failed in the Senate, so important issue, but we'll continue to work on this, and I'd like to take that off notice.
All right. Without objection, House Bill 2209 will be off notice. Item number 38, House Bill 2212 by Representative Powell.
Thank you, Mr. Chairman. So this bill was written to prevent government overreach. Actually share a lot of the same concerns as Chairman Holsey when it comes to the Fourth Amendment. Right now, there's a loophole that allows government agencies to purchase data from private brokers. I've heard from a lot of different people that have an amendment that actually worked out to make sure that work out some of the different concerns from like the insurance industry. But what it was trying to do is not restrict law enforcement from doing their job, simply require them to follow the Constitution while they do it. I do think there are a lot of attacks right now to the Fourth Amendment and people being tracked, the location, access to personal data particularly. And there's nothing that currently stops a government agency from paying a private data broker for the same information. I have, though, been working with our district attorneys and others to kind of continue to work on this bill. There's some issues that I need to work on as far as warrants are concerned. So again, this issue I'll continue to work on. I might be adopting the PEEPS legislation from Chairman Holsey. And with that being said, in the spirit of Easter and PEEPS, I'll be taking this off notice.
All right. That objection to House Bill 2212 will be off notice. Item 39, House Bill 2504 will be rolled to the HILP. House Bill 483 will be rolled to the HILP. Item 41, House Bill 2472 by Representative Grills. That was summer studied in the Senate. Without objection, we will take that off notice. Item number 42, House Bill 2157 will be rolled to the HILP. Oh, we did?
Yeah.
Okay.
That's off notice. That goes off notice as well.
All right, let's go to item 49.
Motion.
House Bill 1962 by Chairman Farmer. You have a motion second. You're recognized.
Very good, members. What this bill does, if you commit an aggravated assault, currently that's as range one, that's 3 to 6 years, and there's a presumption of probation with that. What this bill says, if you commit an aggravated assault and use a weapon to do so, we're going to remove that presumption that probation is warranted, and that way the judge can sentence appropriately. And that's what the bill does.
Any questions for the sponsor on the bill? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 1962 to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, 0 noes, and 2 present not voting.
The ayes prevail. House Bill 1962 moves on to full judiciary. Members, let's go to item number 77, House Bill 2606 by Representative Salinas. You recognize there's Amendment Code 15513.
Yes.
You're recognized on the amendment.
Fellow members of, on the amendment.
On the amendment.
Second.
Yeah, you're good on the amendment. You want to adopt the amendment?
Yes.
Okay. All those in favor of adopting Amendment Code 15513 on the House Bill 2606, say aye.
Aye.
Those opposed, the ayes prevail. We adopt your own your bill as amended.
Okay. Thank you, Chairman. What this bill does is it would create a cold case department within the TBI. Currently, there's only one position that takes on cold cases here in Tennessee. I was very surprised to learn that Tennessee didn't have a cold case department. Obviously, we know that oftentimes if you commit a crime, you're more likely to commit other heinous crimes. And our technology has gone way further than it has been in the last 10 years. We're able to do a lot of more deep sequencing, single cell sequencing, as well as genetic genealogy. We have a lot more tools. So what this bill would do is it would give people that have had their cases not decided 10 years or higher, I think it would bring them and their families hope and justice. So with that, I stand for questions.
Thank you very much. Any questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2606 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes and 0 noes.
The ayes prevail. House Bill 2606 moves on to full judiciary. Members, we're going to stop right there. We're going to take a recess until 3 p.m. today. We'll be back in this room. So we look forward to seeing you again later on.